Supreme Court previews. This is an event which ACS is very proud to host each year in order to provide members of the Washington and Lee community and members of the broader community with some perspective and context and commentary on important cases that are before the court during the term. This promises to be a very exciting term. Of course, there's a new intellect and a new personality on the court in the person of Justice Sotomayor. It remains to be seen how she may shape some of the decisions that will come down in the spring. We have another all-star cast here lined up for our preview this year. For outstanding faculty members to talk about 4 cases which they all believe are cases which may fundamentally change the shape of American jurisprudence and the way that we live our lives. I'd like to introduce our first professor, our first speaker, someone who needs little or no introduction in this forum. That's Dean Smolla, the Dean of our law school, and the Roy L. Steinheimer Professor of Law. This is Dean Smolla's 3rd full academic year here as Dean at Washington and Lee. He comes to us by way of the University of Richmond School of Law, and before that, the Marshall Wythe School of Law at College of William & Mary. He's a graduate of Yale and Duke Law School, and he shares a distinction with Wizard White, Justice White, having been a football star in college. And my legal research skills failed me this afternoon when I tried to find out what position you played. Successful in that. I think Wizard White was a halfback. During Dean Smolla's academic career, he's received numerous teaching awards. He's an active litigator as well in matters involving constitutional law, civil rights, mass media law, advertising, defamation, and privacy law. And in fact, he's the co-author of an amicus brief in the case we'll be discussing tonight, U.S. v. Stevens. So please join me in welcoming Dean Smolla.
Thanks, John. Well, I will disclose that, as John suggested, I'm a tangential participant in this case, United States versus Stevens. I was in a group of constitutional law professors that helped write an amicus brief on behalf of the respondent, so that is to say against the United States and on the side of arguing that the law at issue was unconstitutional. But I'm going to do the best I can to present the arguments objectively for you. The case, which has already been argued, involves a federal law that makes it a crime to traffic in graphic images of animal cruelty for commercial purposes. And so the law has a whole litany of triggers, but the gist of it is that if for a commercial purpose you publish or transmit images of animals being maimed, tortured, killed, etc., you commit a violation of federal law. The action in killing the animal has to be illegal, but it doesn't have to be illegal in the place where the animal is killed. It only has to be an illegal act in the place in which the images are transmitted or produced. The case probably has attracted a substantial degree of public attention because of Michael Vick and the notorious conviction of Michael Vick for dogfighting, because the films at issue, which are films produced by another Virginian, do depict dogfights, and that is one of the, I think, backdrop cultural issues that has drawn a lot of attention to the case. The case from a broader First Amendment perspective, though, is a very, very interesting test of 2 fundamentally different conceptions of what modern First Amendment doctrine is. The government's contention, the contention of the United States, is that the best way to understand the case is as a application of one of the most famous and significant free speech cases ever decided, a 1934 case called Chaplinsky versus New Hampshire. Chaplinsky is a case in which the Supreme Court said that there are certain narrow, well-defined categories of speech, the prohibition of which has never been thought to pose any constitutional problem. And the court then gave a series of examples. Among these categories, the court said, are the profane, the libelous, the so-called fighting words. And the court then gave you its theory. The court said speech like this, profanity, libelous speech, obscene speech, fighting words, are all examples of speech that contribute little, if anything, to the marketplace of ideas. They do virtually nothing to add anything to public discourse, but they whatever little bit of addition they give to public discourse, they are a serious affront to law and morality. And the negative impact on law and morality caused by this very low-grade, very inconsequential speech is such that the balance tips well in favor of allowing the government to ban it. The Chaplinsky case has been a battleground in American free speech law for decades, ever since 1934. One of the questions in the case is whether the court intended to carve out a series of specific categories so that if speech falls into one of these categories, it can be prescribed. But if it's not within those narrow categories, it cannot be prescribed. Many free speech advocates have argued that that's the best way to understand Chaplinsky. If you make that argument, dogfighting or animal cruelty doesn't fit within the list, and therefore the government would not be permitted to ban it. But the United States says, no, that's not the proper way to understand Chaplinsky. That's not the generous way to understand the point of the case. The point of the case, the government argues, is that in fact in a decent society it's possible to say there are certain kinds of speech that just have no plausible claim to doing anything to elevate our discourse, but clearly are highly offensive and can cause harm to society. And the court was merely giving you examples. It wasn't intending to lay down a strict, airtight doctrine that would last. It was merely giving you evocative, representative examples of speech that falls into that category. And this speech, the government says, fits perfectly in that category. And it points to a number of things that Congress engrafted onto that statute to ensure that no speech that has any conceivable claim to having any value in the American marketplace of ideas can ever be prosecuted, and only speech that fits within that spirit or that philosophy of Chaplinsky can be reached. So, for example, this law is limited to speech in which the underlying activity, as I've already said, is illegal in the place in which the speech is produced. I guess the hypothesis there being, if you cannot have a dogfight, if you have the right to prevent that, you ought to be able to prevent the secondary trafficking in the images of the dogfight, which create a market, a commercial market for the underlying illegal activity. But most powerfully, the government's best argument is that the statute has a caveat. Borrowing from obscenity laws, which have been upheld in scores of cases against constitutional attack, this law, borrowing directly from American obscenity law standards, specifically says that it is a defense if the speech has redeeming social value. And in fact, Congress said in the law that there could be no prosecution under the statute if the speech has redeeming, and then it lists a whole plethora of redeeming social value, essentially the entire curriculum of the College of Liberal Arts. So speech that has any conceivable political, entertainment, artistic, cultural, religious, scientific value, any speech with any value defined as broadly as one can imagine, cannot be prosecuted under the statute. And it's against that backdrop that the United States says, in this case, there is clearly an act directly contrary to what Congress has prohibited, and Congress has the right to prohibit it under the Chaplinsky formulation. The other side of the case in which I participated in, makes a number of arguments. The first is that Chaplinsky is no longer good law, that Chaplinsky ought to be understood as a case that time has passed by, and that although the case continues to be cited in the Supreme Court, it's frequently cited, and although certain sound bites from the case are often invoked, the ones I just gave you, for example, are repeated constantly in American judicial opinions, that as actual functioning First Amendment doctrine, it's obsolete. There are a number of attacks on the case. The first is that even if you take Chaplinsky by its own terms, in terms of the categories, you see that it has largely been undermined. So, for example, Chaplinsky suggests that you cannot ban profane speech. But for a long time, the Supreme Court has made it clear that mere profanity in the sense of swear words or taking God's name in vain cannot, standing alone, justify an abridgment of the First Amendment. And so the most vulgar word in English, fuck, which was a part of a very famous case, Cohen versus California, in which someone wore on the back of a jacket in a courtroom, F the draft, all right? The Supreme Court in Cohen said the First Amendment prohibits imposing criminal liability for that. And one can point to many, many, many other cases in which the Supreme Court has said mere vulgarity alone, mere profanity alone cannot be prescribed under the First Amendment. Libel is another example. Chaplinsky suggested that libelous speech was not protected by the First Amendment. But at least since 1964, in a case called New York Times v. Sullivan, and many, many, many subsequent cases, the Supreme Court has created First Amendment doctrines that generate a great deal of protection for libelous speech on matters of public concern, particularly involving public officials and public figures. Even fighting words has been dramatically narrowed, so that the Supreme Court has imposed upon the fighting words doctrine requirements of immediacy and intent that meet traditional modern First Amendment standards, sort of the modern version of the old Oliver Wendell Holmes clear and present danger test. Obscenity stands alone as the one example of the Chaplinsky categories that remains still intact, because if speech is declared obscene, it still under current doctrine receives no First Amendment protection. But that's the only part of that formulation that remains intact. But there's a broader philosophical challenge to Chaplinsky that is fascinating. The broader philosophical challenge is that absolutely brilliant one-sentence justification given by the court, which is very, very, very appealing, that this is speech that adds nothing to the marketplace of ideas, but does huge damage to the polity. The broader attack is that has been rejected, that the Supreme Court has rejected the view that the government can be an umpire judging the worth of speech and its contribution to the marketplace, and that instead the government bears the burden of proving palpable harm, direct harm, in some immediate sense every time it seeks to abridge freedom of speech. I have a minute left. I'll just give you a quick sort of reconciliation. I happen to be of the view that both the Chaplinsky understanding of free speech and the alternate free marketplace understanding of free speech are alive and well in the United States and ought to be. And that the doctrine that has existed up to the Stevens case is that the free market theory has now trumped the Chaplinsky theory in the general marketplace of public discourse. But the Chaplinsky theory trumps the free market theory in isolated domes, in which there is a dome that surrounds the arena in which the speech is given, in which we are saying general marketplace principles do not apply here. Instead, here we care more about order and morality than we do about the absolutely robust, unfettered free exchange of ideas. And so we tilt the balance one way in these special settings and a different way in the general marketplace. The special settings involve situations such as schools, where the Chaplinsky rule trumps, or government employment, where the Chaplinsky rule trumps. There are a few other settings in which the court has clearly said that the formulation in Chaplinsky, in which order and morality are entitled to greater weight than anything goes speech, when one of the great battlegrounds in American society are universities, public and private universities, where some advocate we should have the free market theory that trumps, but others say no, a university is an ordered and a moral space and place in which traditions of civility and discourse, academic rigor, discipline, respect for community should trump. The court's being asked to decide this case, though, in the open marketplace. This is an open marketplace case, and those who are opposed to the recitation of Chaplinsky in the open marketplace fear that it would open the door to the overruling of 20 or 30 Supreme Court precedents that have established this very robust protection of freedom of speech, and allow the government to, in effect, take any speech that it deems offensive and say, we think of this as the equivalent of obscenity, and thereby ban it. The reporting on the oral argument was that most of the justices in the argument appeared hostile to the United States and hostile to the Chaplinsky-style argument. The only justice who seemed sympathetic was Samuel Alito, but that's not always a good bellwether as to what the court will do. Thanks.
Thank you, Dean Smolla, for that fascinating work. Next, we have Professor Scott Sundby, who is the Sidney and Francis Lewis Professor of Law. He focuses mainly on criminal law and procedure. Following his graduation from Cornell Law School, he clerked in Georgia and taught in California for 9 years before coming to W&L in 1992. Professor Sundby has contributed to W&L both through his excellent teaching, and I should know since I'm in his criminal procedure class right now, and through his supervision of the Virginia Capital Clearinghouse. He's also renowned for his legal research, especially in jury verdicts in capital cases, and has been published in law journals across the country. Please help me welcome Professor Scott Sundby.
Thank you, and it's a pleasure to be here this evening, in part because I think it's a wonderful event. But also, I don't get to hear my colleagues present that often, and it's really a pleasure to see why you have such a high opinion of my colleagues. So I enjoy this for a number of reasons. The two cases I wanted to talk to you about tonight come about because of two trends that have been developing that have finally come into sort of a convergence. Both started around the mid-1980s. The first is the increasing use of life sentences for sentencing. In the United States right now, and this stunned me when I actually looked up the statistic, 1 out of every 10 prisoners in the United States is currently serving a life sentence. And that trend has doubled over the past decade alone and is projected to keep increasing at an accelerating rate. So more and more people, and of course the United States has the highest incarceration rate of any Western country, more and more individuals who are being incarcerated are being given life sentences. At the same time, again starting around the mid-1980s, the number of individuals who were juveniles at the time that they were convicted of their crime have under state statutes been able to be treated and prosecuted and sentenced as adults. This came about during the mid-'80s when there was a sense that there was this new form of juvenile they referred to as super predators. Time magazine had a big cover. There were several very notorious high-profile events. In Florida in particular, there were some foreign tourists who were murdered by juveniles, and Florida all of a sudden became a place that the headlines were saying, don't go there because it's dangerous. And as a result, Florida and other states started to pass laws that really tightened down on juvenile crime. And not unexpectedly, as more and more juveniles have been prosecuted as adults, eventually some of them got prosecuted under crimes which resulted in life without parole sentences. And the court has granted cert in 2 cases. They are companion cases, which means that they will be decided separately, although the court very carefully granted cert in both cases for reasons that I'll suggest at the end of my talk. But the first case is the case of Joe Sullivan. He is one of 2 individuals who was committed a crime at the age of 13 and is currently serving a sentence of life without parole. So when he was 13, he was convicted of raping his 72-year-old neighbor. And when he went before the judge said, you've had several other brushes with the juvenile law. I think that there's no hope for you, and therefore I'm going to sentence you to life without parole. So he is one of 2 13-year-olds who committed a non-homicide crime and received a sentence of life without parole. Helpful to know that Joe Sullivan also happens to be mentally retarded, and he came from a home where he had been abused as a child. And so it's a tough situation that he is coming out of, but the judge said, I see no hope for you. The second case is a case with an individual named Terrence Graham. Terrence Graham was 16 when he and 2 companions entered a restaurant. And they robbed the restaurant, and in the process, the manager was hit with a steel bar. Graham was not the person who hit him, but luckily the manager survived. And when Graham came up for his trial, the prosecutor elected to prosecute him as an adult. The trial judge said, okay, I'm going to give you a break. I'm sentencing you to 3 years on probation, but you're also going to have to serve 12 months in the county juvenile detention center. Graham served his 12 months. 6 months later, he leads an armed home invasion. 2 other people, not the same 2 who had been in the first one. He's now 17 years of age. And among other things, he points a gun and threatens to kill the homeowner, terrorizes the family. He's eventually caught. He, to this day, denies that he was in on it, but a probation violation hearing was held. Not a separate trial, but a probation violation hearing because he was on probation from the restaurant robbery. And the trial judge finds that he committed the second event and says, listen, you got a real break the first time around. You went out, you abused your chance for a second chance, and therefore I'm going to sentence you to life without parole. And he is now one of 77 individuals who, as a juvenile, committed a non-homicide crime and is serving a life without parole sentence. And these 2 individuals are arguing to the United States Supreme Court that their sentences violate the 8th Amendment ban on cruel and unusual punishment. And the reason why all of a sudden there's extra constitutional traction to their claim is because in 2005, so 4 years ago, in a case called Roper versus Simmons, the United States Supreme Court struck down the death penalty for juveniles, reversing a decision that they had made 20 years earlier, which had said that the juvenile death penalty did not violate the 8th Amendment. They changed their tune in 2005, and Sullivan and Graham are arguing that for the same reasons that the juvenile death penalty was unconstitutional, you ought to find that a life without parole sentence is also unconstitutional. And that reason is because the core of Simmons, Roper versus Simmons reasoning is that juveniles are a unique class of offenders, that they have a distinct culpability that distinguishes them from adult offenders, and therefore they should never be subjected to a sentence which is unalterable. Of course, the death penalty is unalterable, but their argument is so is life without parole. You send me to prison, I will never get out of prison. I'll be there 10, 20, 30, 40, 50 years, however long I live there before I die. And therefore they say Roper versus Simmons is violated, the principle, with a life without parole sentence as well. And to do this, they rely on the scientific literature, which the court turned to in Roper. And for those of us who have teenage kids, the scientific literature simply confirms what we know, which is that teenagers are a work in progress. And in fact, what we have found, and what they're now physiologically finding, is that brain structure actually changes when you are 13, 14, and 15. You get more white matter, which is necessary for rational processing, and your gray matter is cut back. You actually lose gray matter, what the neuroscientists refer to as synaptic pruning. I love that phrase, synaptic pruning. But you actually have to have that in order to be a more efficient decision maker. Well, 13, 14, and 15-year-olds do not have those are the processes that are going on, and therefore they are not good at decision making. They are more impulsive, and we all know this, right? From you may remember this from not that long ago. You were more impulsive. You did not contemplate what you were doing, and you were more susceptible to peer pressure. The analogy which is often used is that it is like a teenager at this age is like a car with a very powerful accelerator and very weak brakes. And I always think that if Mother Nature actually did make cars like that, she'd be in receivership along with GM, right? And, I mean, who's thinking here, right? But that's the analogy which they make. And the important point of this is that, therefore, things that you do when you are 13, 14, 15, on up until 18, are things which you may not do once your brain fully forms and once you gain the experiences which we all use to alter our behavior. And in fact, studies show that 90 to 95% of individuals, juveniles, who commit crimes before the age of 18 will not be criminal offenders once they reach adulthood. And very importantly, for Sullivan and Graham, those studies also find that there's no way to predict who will be the 5 to 10% who later offend. There's just no way to predict it, and psychiatrists and criminologists refuse to make those predictions. So their argument is, you are sentencing individuals, when you give them juveniles, a sentence of life without parole, based on assumptions which you have no business making as the trial judge. And both briefs quote extensively from the trial judge at the sentencing of Sullivan and Graham, where they say, listen, you're hopeless. You got a second chance, and you blew it, and it's clear you'll never change, and therefore I'm sentencing you to life without parole. And the premise of Sullivan and Graham is, wait a minute, that was a judgment that the court in Roper v. Simmons said you simply cannot make based on the science that we know. They also bring in other aspects which the court in Roper relied on, one being the international aspect. The United States is the only country which sentences juveniles to life. We are one of 2 countries that have not signed the Convention for the Rights of Children, the other one being Somalia. A resolution was introduced before the United Nations to ban life sentences for juveniles. The vote was 175 to 1, and you can guess who the one was, right? And so the argument is, listen, the United States is completely out of step, and therefore this violates basic norms of decency, which is the foundation of the 8th Amendment. The state of Florida, on the other hand, says, wait a minute, Roper v. Simmons is a death penalty case. And there's a relatively robust series of Supreme Court decisions which have interpreted the 8th Amendment in terms of the death penalty. But boy, once you leave the death penalty, you go into a barren constitutional terrain. The Supreme Court, with sentences of terms of years, has notoriously said, we're not going to go there. Those are legislative judgments. Those are the types of decisions which we think, as a court, we cannot make. And therefore, we are going to be very, very deferential. And of course, the state of Florida is saying, this is a non-capital case. So you really have no business, U.S. Supreme Court, in even entering into here. There's actually 2 votes on the Supreme Court, Justices Scalia and Thomas, who take the position that the court has no business at all in passing judgment that the 8th Amendment ban on cruel and unusual punishment was meant only for methods of punishment. There is a plurality headed by Justice Kennedy, which says that in rare cases, extraordinary cases, a sentence may be so grossly disproportionate, that's the magic phrase, so grossly disproportionate that it may violate the ban on cruel and unusual punishments. But here is the example which is always used. It's an example Chief Justice Rehnquist gave when he said, well, I joined that group. He said, perhaps, he starts off the sentence this way, perhaps a sentence of life for overtime parking may be grossly disproportionate. If that is your standard, you can imagine how difficult it is. In 6 cases over the last 20 years, the Supreme Court has considered these types of cases. They've upheld a sentence of 40 years for possession of 9 ounces of marijuana. They've held up life sentences for someone who had 3 property offenses that totaled $230. They've upheld life without parole sentences under the California 3 strikes and you're out rules, where the last offense was stealing $150 worth of video cassettes. So the court, with one exception, which has probably been effectively overruled, is afraid to go into this area, in part because they say, how will we draw lines if we do this? And so the real tug of war here is, will they treat it like a Roper death penalty case on this idea that life without parole is an unalterable sentence, or will they treat it like there are other cases which are for sentences less than death, where they say we don't want to go there? Couple final observations, and then I'll turn over the podium. First, it seems very clear that the court deliberately chose Sullivan and Graham's case possibly as a way to draw a line. Because one thing which the court can do is say, all right, in Sullivan's case, especially since the scientific literature tends to suggest that these brain structure changes tend to mature at the age of 15, what you could say is that for an offender who is 13 and 14 and perhaps 15, life without parole is unconstitutional. 16 and older, which is a natural dividing line which we're used to, that's when you can drive, that's when you can get married with your parents' consent, things like that. Maybe in those instances, life without parole will be okay. And there's a real tension, by the way, between Sullivan and Graham's briefs, because Sullivan keeps saying, oh, if you need a line, 15's a good line. Graham, of course, says, hey, wait a minute, what about me, right? And so there's a real tension that's going on there. Second thing, If you want to read a superb Supreme Court brief, read the brief for the petitioner in Sullivan. It's written by Bryan Stevenson, who is truly one of the great criminal litigators in the United States. He's a MacArthur Grant Genius recipient. He's talked here a couple times. It is brilliant. You can see why he's been labeled a genius. Among other things, one of the things he effectively does, in the background of Sullivan's case, and he was convicted, by the way, 20 years ago. So he's now 33. He's in a wheelchair. He suffers from MS. And he's still in prison. Obviously, will be for life unless the court rules for him. And there is now a suggestion that he was wrongfully convicted, because he was convicted of the rape when he had a companion with him. His lawyer, who has since been disbarred, made no challenge to any of the evidence. The woman never saw her attacker. She was blindfolded right away. And she made a voice identification. And voice exemplars is junk science by any measure. And he never appealed. He filed what's known as an Anders brief, the same lawyer who failed to put up any fight for Sullivan at trial. And of course, since that time, the physical evidence, which could be DNA tested and show whether Sullivan did it or not, has been destroyed. And one thing which Bryan Stevenson is very effective at doing is he brings this notion in through the back alley, because, of course, a straight Eighth Amendment argument, this wouldn't be relevant. We have to assume that he's guilty. But he says, juveniles are more likely to be erroneously convicted, which is another reason you ought to take into account under the Eighth Amendment before you give someone a life without parole sentence. And he has statistics showing that the younger you are, the more likely you are to falsely confess. It's not that strong an Eighth Amendment argument, but it's a brilliant way to put before the court the idea that he, in fact, may be innocent, and he has no way now to ever get out. Final thing I'll make, especially a point I'll make since Dean Smolla was talking about his amicus brief. This was a really funky amicus brief here, which I remember when I first saw it going, why is this here? It's from Alan Simpson, who you won't remember, but we do, who was the Republican senator from Wyoming for 30 years, starting in the mid-1970s. And he files this amicus brief on behalf of Sullivan and Graham. He's since retired, and I was wondering, why is this? And you open it up, and the opening line of his amicus brief is, when Simpson announced his candidacy for the Senate in 1977, one man stood out in the crowd, J.B. Mosley, Simpson's probation officer. And he goes on to tell how Simpson, when he was 16 and 17, committed a number of crimes, some of which would now carry a possible life sentence, and that he was, in his own words, a monster. And that it was only because he got a probation officer, and not only was given a second chance, but a third and fourth chance, that he turned his life around and eventually became a U.S. Senator. And it's the type of amicus brief which, if you're sort of looking for a real-world example of, someone who says, hey, listen, my brain structure, I had a really strong accelerator and really weak brakes. It's a very effective example. Thank you.
Thank you very much, Professor Sundby. Next we have Professor Brian Murchison, who is the Charles S. Rowe Professor of Law. He focuses primarily on torts and administrative law and is renowned for his work in torts. Following law school at Yale, he entered private practice with a law firm in Washington, D.C. before coming to Washington and Lee to begin a remarkable career here. Over the years, Professor Murchison has served in a number of different capacities as a professor, as a supervisor of one of our clinics, and even including as an acting dean of the law school not too long ago. And I was even so lucky to have had him last year in my administrative law class. And so please help me welcome Professor Murchison.
Can there be a fifth branch of government? The very phrase conjures up a frightening vision of a dark landscape, dense mists, dotted by odd, misshapen structures, strangely hammered together entities on a darkling plain, the products of some awful experimental carpentry, some unholy artifice, a fifth branch of government. Well, petitioners in free enterprise fund versus public company accounting oversight board will conjure that image, or maybe in somewhat different terms. On December 7th, when the petitioner's lawyers present their case to the U.S. Supreme Court, the case is a facial challenge to Title I of perhaps the most controversial statute in recent years, the Sarbanes-Oxley Act of 2002. Remember, which was enacted by Congress in the wake of the Enron and WorldCom accounting scandals to protect investors by regulating accounting firms. It was signed into law by President George Bush. It's now being defended by Solicitor Kagan and the Obama administration. The Sarbanes-Oxley Act. Well, the petitioner of this free enterprise fund is a nonprofit advocacy group based in D.C. It's all about limited government, and it's very appalled by the Sarbanes-Oxley Act. And its co-petitioner is an accounting firm in Nevada, Beckstead and Watts, which is now undergoing investigation by this agency that's been created, by this thing called the Public Company Accounting Oversight Board, shortened to Peekaboo. It's P-C-A-O-B. And so it's called Peekaboo. And this accounting firm that's one of the petitioners is under investigation by Peekaboo. And the accounting firm is challenging the very constitutionality of the statute that creates the investigating agency. Representing the petitioners is going to be Kenneth Starr, ex-judge, ex-solicitor general, ex-independent counsel for Whitewater, current law dean, Kenneth Starr. And he's going to be joined by Michael Carvin of the Jones Day firm in D.C. Okay, they will argue that in Sarbanes-Oxley, Congress established a mutant administrative agency, although calling it a non-governmental corporation, this Peekaboo agency, that it encroaches on presidential powers, that it adds to congressional powers, that it subverts the separation of powers in the constitutional design, and therefore threatens individual liberty by creating an agency in the government that's essentially accountable to nobody, particularly not accountable to the president, but is engaged in the execution of law. So Kenneth Starr will get up there and he'll say, this statute was well-intentioned. It was an understandable reaction, but an overreaction to the Enron and WorldCom scandals. Kenneth Starr will say that the statute in setting up this agency sought to create a body that would be independent of political influence, an unassailably upright and uncaptured regulatory body. In the 60s language, unbought and unbossed. That this agency, Peekaboo, would be answerable only to itself and to the law. And that the accounting firms would have to sit up and take notice and get their acts in order because Peekaboo was out there. And it was totally independent as a law enforcer. But, Kenneth Starr will add, Congress went too far and placed this agency beyond constitutional norms of accountability. He'll also say it's easily fixed, it's easily amended with no loss to the public policy goals that were behind it. Okay, a big part of the argument on December 7th is going to be the justices sitting up there asking all the lawyers about this agency. Okay, what kind of agency is it? It's the fifth branch? Does that even exist? What did Congress intend? And the lawyers are going to have to be very careful, because a search through the legislative history shows a Congress hurriedly enacting Sarbanes-Oxley and not really being at all sure what it was that was being created. In fact, the statute itself says that the agency is an independent private board. The statute itself says this is not an agency or establishment of the U.S. government. The statute itself says no member or person employed by this agency shall be deemed to be an officer, an employee, or agent of the federal government by reason of such service. The legislative history has then Senator Graham saying, yeah, it's a strange kind of entity. We wanted it to be private, but to have governmental powers. And you have then Senator Sarbanes saying, yeah, we created it as it was in order to provide an extra guarantee of its independence and its plenary authority to deal with this important situation. The Solicitor General will say, yeah, that's okay. It was based on things like the New York Stock Exchange, like the National Association of Securities Dealers, these sort of private corporate entities that have regulatory functions but aren't government agencies. That's what Congress was trying to do in its own sort of inept way. The only problem is that those entities, the New York Stock Exchange, the National Association of Securities Dealers, neither of them was really created by Congress, and the government doesn't appoint their officers. So it's quite different from those things, and she's going to have to stretch a little bit to say that it's just like those things. Now, look, the question will be, is the thing constitutional? That is the very bread and butter, the very marmalade, the green tea of a first-year course at this school, all about the structure of government. In that course, I think it's called the American Public Law Process, the professors very gently lead the students through some very kind of mild labyrinths of Articles 1, 2, and 3 of the U.S. Constitution, where we have three branches pretty carefully spelled out. In that course, yeah, there is some frightening stuff. There is some unveiling of what's known as the fourth branch. And it is kind of a forbidding moonscape of a sort. The realm of those alphabet agencies that have proliferated since the end of the 19th century and have posed considerable questions of constitutionality, at least since the 1920s. How are those entities reconciled with the written Constitution, which appear to be the sum total of the limited government that the framers had in mind? The course goes to some lengths to say that some part of the fourth branch has been deemed constitutional. Other things have been uprooted and tossed into the fire as unconstitutional. And the course says that there's this thing called the independent agencies, that the fourth branch has these things called independent agencies. Federal Trade Commission, Federal Communications Commission, National Labor Relations Board, and so forth, that are set up by Congress to be independent of the President. That the President gets to appoint them with the Senate's confirmation, but the President cannot remove them at will. The President can only remove them for certain specified causes, and therefore doesn't have direct day-to-day total control over them. Hence, they're independent agencies. And they're kind of weird creatures, and that's why we have a fourth branch. That's why we call it the fourth branch. It's of constitutional, it's a bit questionable. But in 1935, the Supreme Court, not a very distinguished court in 1935, but at least a court in 1935, upheld the independent agencies as constitutional. But it was the independent agencies in 1935. 70, 80 years have passed. They're different now. They exist. They're constitutionally questionable. They exist, and no federal judge yet has had the guts to do anything about them because we need them too much. They're too necessary the way things are. Fourth branch, shaky, but they're likely to stay. This case that I'm telling you about is about something called what Kenneth Starr will call the fifth branch. Of course, he's trying to strike fear in the hearts of the justices by calling it that. But he's trying to say this is one step beyond what we've gotten used to. Peekaboo, that agency that's investigating accounting firms, is not appointed or removable by the president. It is appointed, the members are appointed by the SEC commissioners, the Securities and Exchange Commissioners. They get to appoint the members of this new board, and they can remove those board members only for very limited stated causes. So Kenneth Starr will say to the justices, this is one step beyond what we're sort of okay about. This is not the president being even half in charge. It's the president being totally attenuated, and the SEC, which is an independent agency of the president, appointing and having removal powers over a body that's independent of the SEC, that's independent of the president. He'll say that is this weird, smoky, misty, awful terrain known, he'll call it the fifth branch, and he'll say you got to stop it. He'll make two specific arguments. One, appointments clause of Article 2 violated. The appointments clause is written in 1787. We're still following slavishly today. It says principal officers of the U.S. have to be appointed by the president with the Senate's confirmation. Kenneth Starr will say peekaboo has tons of power. Rulemaking, adjudication, enforcement. They can do anything about law enforcement. They're principal officers. They're not appointed or removable by the president. Appointments clause problem. He's got a backup argument. He says even if they're not principal, even if they're inferior officers, they still have to be appointed by that clause. And the Constitution says inferior officers can be appointed by heads of departments. He'll say, okay, even if they're inferior officers, they're being appointed by the commissioners of the SEC. The SEC is a department, and the commissioners sort of together are the head. So he'll say, this is a problem, appointments clause. That nobody could really subscribe to the notion of the SEC as a department. It's not a cabinet level department, and therefore even that presents a constitutional problem. He'll also say that there's a take care problem. Under Article 2, the president gets to take care, has a duty to take care that the laws be faithfully executed. There's no way the president can take care about anything about peekaboo. He's too attenuated in terms of control. Elena Kagan, or the solicitor's office, will get up there and say, it's not so bad as Kenneth Starr makes it look. She'll say, the SEC gets to control just about everything peekaboo does. The SEC has statutory power to delete things that it doesn't like, to reverse this board, to exercise de novo review, to take away some of their powers. The SEC's in charge. That this board is really just kind of an adjunct to the SEC. And since the SEC's constitutional, so is this new little adjunct. Not to worry. Constitutional, not an appointments problem, not a take care problem. Uphold the thing. And probably she'll say, with new problems, we need new structures. We got to really send a message to the accounting firms that we've got a sheriff on duty and who's going to be independent of politics. And so we have constitutional justification and policy grounds. What will probably happen in this case? Separation of powers cases don't really nicely sort the justices out as liberal or conservative. Back in the 1980s, Justice Brennan was pretty much of a purist on separation of powers grounds, and so was Justice Scalia. They didn't really agree on a whole lot of other things, but on separation of powers things, they were both pretty tough on Congress. They both felt that Congress should not tinker with the separation of powers. That the structure of government really is all about the liberty of the individual, and that the court's job is to police congressional experiments and not to permit those experiments that allow power to be concentrated and the individual liberty to be jeopardized. So you're going to get a lot of talk about liberty, constitutional structure as protecting liberty. Question is, who will win this case? The court below, the D.C. Circuit, upheld the statute on the adjunct to the SEC theory. The lower court in the D.C. Circuit, a Clinton appointee and a George Bush appointee, 2 votes to 1, upheld the statute. The dissenter was a George Bush appointee who said this is the most important and disturbing separation of powers case in 20 years, and the fifth branch of government should be strenuously resisted by the courts. What do I think will happen? I think if congressional intent were a little clearer, if Congress had really said what it was planning to do, the statute would have a better chance. The intent of Congress is very hard to pin down here. Whether it was intending to create a private sector regulatory corporation, whether it was trying to create a adjunct to the SEC, or whether it was trying to create something really new, different, totally not seen before. The court's going to have to figure out what it was Congress sort of intended to do. The court can either strike the thing down as unconstitutional or interpret it into constitutionality, which the court is very good at doing. Sort of narrow the thrust of the statute sufficiently so that it passes. Somebody will argue new problems need new solutions. An old document like the Constitution really shouldn't govern. It should govern, but it shouldn't be the final criterion. That really policy should guide this decision. And the only way to really sock it to the accounting firms and to get them to do their job is to scare them by having this independent body. My guess is that the court will think that new problems do need new structures, but that the newness doesn't have to be quite as dramatic as the newness of this body. So if I were a betting person, which I don't know if I am or not, I would say that they would probably strike the thing down or reduce it through interpretation. Last thing I'll say, it's a facial attack on the statute, and it's a little harder to win that kind of an attack. So it's anybody's guess. Ironically, the Obama administration is supporting this statute that attenuates power away from the president. However, all of its own initiatives are really to bring more power into the executive, not to attenuate it. So the Obama administration is in a little bit of a schizophrenic situation here. It's defending this weird statute, but it's got a Solicitor General who's written articles sort of decrying this kind of thing. And some of her articles will probably be quoted to her as she stands before the court. It should be very entertaining.
Thank you, Professor Murchison, for that chilling glimpse behind the curtain of the branch. Our concluding speaker this evening is Professor David Millon. He's the J.B. Stumbach Professor of Law at Washington and Lee, where he has taught since 1986. In his years here, he's served as an Associate Dean for Academic Affairs. He's been Director of the Francis Lewis Law Center. He's a graduate of Ohio State and Harvard Law School and earned a Ph.D. in History at Cornell. At Washington and Lee, his other involvements have extended to the Shepherd Poverty Program, advising the Washington and Lee Law Review, and serving on the University Athletic Committee. He's written academically on topics as varied as postmodern corporation, corporate social responsibility, and ecclesiastical jurisdiction in medieval England. And tonight he'll be speaking to us about some rather different jurisdictional issues. Please join me as welcoming Professor David Millon.
Wow. three really hard acts to follow. I have one thing working in my favor. I'm not going to be talking about the philosophy of free speech or the implications of neuroscience for criminal justice or even the dark corners of separation of powers doctrine. I get to talk about money. Jones v. Harris is a case that is about money, purely and simple. And so this is something we can all get excited about, even with the right here. The issue it sounds narrow and technical, but I'm going to try to, after I explain to you what the case is about a little bit, I'll give you some sense of why the case actually is of broader interest and actually quite important. The technical issue is whether the managers of mutual funds can be held liable for charging excessive fees. Whether the people who manage mutual funds can be held liable if they charge too much money for the work they do. And there's a statute, a 1940 statute called the Investment Company Act. It says that the advisors and managers of mutual funds owe a fiduciary duty to the fund and the people who invest in the fund. And then there's a Second Circuit case from 1982 called Gartenberg that held that the fiduciary duty requirement of the statute means that managers of mutual funds can be held liable if they charge too much money, if they charge excessive fees. So there's an established 25-year-old precedent here that is right on point. It does say that they can be held liable, but it also, with the Gartenberg case, also sets the bar very high. Quoting here, to be guilty of a violation, the manager must charge a fee that is so disproportionately large that it bears no reasonable relationship to the services rendered and could not have been the product of arm's length bargain. So the fee has to be just through the ceiling, astronomically, obviously unfair, shocks the conscience kind of thing. And maybe not surprisingly, in the 25 years since Gartenberg was decided, not a single investment advisor has been found liable for charging excessive fees. A little bit of background here. What is a mutual fund? Some of you guys know this, maybe some of you don't. A mutual fund is simple investors, people like us have a little bit more money than we do, invest their money in a fund, and the managers of the fund take the money and buy stocks and bonds and other companies, and so you have a big bundle of securities issued by other companies. And if that bundle rises in value, the people who have invested in the fund make money. If it loses value, they lose money. It's very simple. And the investment advisor, the manager, that's the guy, the man or woman whose job it is to decide what to do with your money, where to invest it. And not surprisingly, they get paid a lot of money for doing that. Tend to be compensated a percentage of the total value of the fund. If there's $1 billion or $10 billion in the fund, they're going to get a percentage of that gross amount. So they're typically making millions and millions of dollars for this work. This case is interesting because the investment advisors in this case were working for a captive mutual fund. They had actually started it themselves, and then they were running it, and the people they were working with were setting their compensation, and they were making massive amounts of money here. Twice as much as the fees that they charge to non-captive independent pension funds that they were also giving advice to. So right off the bat, it smells bad. It doesn't sound like there's much competition here that is pushing down their compensation. It doesn't sound like there's a close connection between the amount they're getting paid and the value of the work they're doing. This case then comes to the Supreme Court from the Seventh Circuit, and Judge Easterbrook writes the opinion for the three-judge panel. And he says, we disapprove Gartenberg. We think that was a bad decision. We don't think the statute, we don't think Congress intended to authorize the courts to judge, to evaluate, to make decisions, to review questions of compensation in cases like this. He says when the statute talks about fiduciary duty, what it means is that these investment advisors must deal fairly with the fund. They can't lie. They can't, when they're negotiating for their compensation, they can't be deceitful. But if the bargaining process is otherwise okay, it doesn't matter what they come up with. Courts have no role to play in reviewing these things, no matter how high the compensation might be. In Easterbrook's view, he says that competitive forces, market forces, really are sufficient to take care of this. If you've got a guy who's advising a mutual fund and he or she is charging too much, fees are too high, that would come out of the pocket of whom? Out of the pocket of the people who've invested money in the fund, right? Because gains would go to them instead of going into the pocket of the advisor. And when people find out about that, when investors find out about that, they have an easy response. They can sell their shares in that mutual fund and invest somewhere else in a fund that is managed by somebody who's charging lower fees. The market takes care of these things. The courts shouldn't be involved. Not only is the market superior, judges are incompetent to decide questions like this, right, because they're not business experts. So that's and you get a unanimous decision coming out of the Seventh Circuit to that effect. And the real question here now going forward is whether this statute, this 1940 statute, the Investment Company Act, does in fact authorize the federal courts to review the compensation of mutual fund advisors for excessiveness. The case is, I think it's interesting, you should think it's interesting and important for, I think, 4 reasons. First of all, obviously the case implicates a much larger issue that everybody is aware of now, the general question of whether executives and managers of top corporations, the biggest companies in America, are being paid too much. Right? We've seen obscene spectacle over the last several years of CEOs of industrial companies and especially financial companies making tens or hundreds of millions of dollars, making huge amounts of money, compensation seemingly unrelated to performance in any kind of a direct way. Right? So we've got a major big public policy issue out there on the question of whether executive compensation is out of hand. This case doesn't deal with that broader issue, right? We're talking only about mutual fund managers here. But Congress and the SEC are looking at the larger issue. They may do something about it. And the way the Roberts Court responds to this relatively more narrow issue will give us some hints about how it might respond if the larger issue ever gets to the court. Second, and really interesting to me, is that the case features a debate, a down-on-the-floor mud wrestling debate between 2 of the leading lights of the law and economics movement, first in the academy and now in the judiciary. And as you know, the law and economics approach to legal analysis basically says markets are good, government is bad, private ordering is superior to sort of governmental regulation and governmental intervention. So there's a strong presumptive suspicion or skepticism about any kind of government intervention, especially in economic matters. Easterbrook, the judge who wrote the Seventh Circuit opinion, was a Chicago law professor for a number of years, was one of the founding figures in the law and economics movement, wrote a number of really important articles and books on the subject, and has continued really since he's been on the bench now for about 20 years to sort of propound those views now from a different behind a different podium. Now here's what's really interesting. There was a petition to rehear the case en banc after the panel decided it. And the full court rejected the petition, said, no, we're going to let the 3-panel decision stand. Judge Posner, also a member of the Seventh Circuit, dissented from the denial of the petition for rehearing. He said, no, this is important. The whole court ought to hear this. I don't like what Easterbrook has said here. Now, who is Posner? Posner is the godfather of law and economics, also a very famous Chicago law professor, and now a very distinguished judge. And so we get the spectacle that we ought to get a kick out of this. 2 of the titans of the right wing there wrestling with each other in the mud. It's lovely to see. Because Posner is really quite blunt about what he thinks of Easterbrook's analysis. He said it was one-sided in character. He said there's serious reason to think that the market is dealing effectively with the question of executive compensation. He says this, quoting, the panel bases its rejection of Gartenberg, that older case, on an economic analysis that is ripe for re-examination on the basis of growing indications, we know this, that executive compensation in large publicly traded firms often is excessive because of the feeble incentives on boards of directors to police compensation. Okay? And he also, Posner also acknowledges an impressive body of academic economic literature indicating that investors, the people who invest in these mutual funds, really don't put any pressure on the managers here to accept reasonable compensation because they don't really pay much attention to what the managers are being paid. Some of this is fairly opaque anyway. It's not that easy to tell. The average investor doesn't pay any attention to it. And therefore, the investors really are not moving their money in and out of these different mutual funds, and there's hundreds of them out there based on decisions about how much the managers are being paid. So the market isn't working, he says. And in any event, all of the managers of these mutual funds are overpaid, so there's really nowhere to go anyway. There really isn't any competition there at all. So what you've got here is two very different views coming from two guys who tend to be on the right wing of these issues about the efficacy of market forces to deal with a very important and difficult economic business phenomenon. Third reason to find the case interesting is that it raises very interesting questions about judicial activism. The Seventh Circuit could have simply affirmed summary judgment for the defendants. Yet again, the plaintiffs lost. Okay, they've been losing for 25 years. They lost again. The district court said, fees not excessive. You haven't proved it. The Seventh Circuit could have said affirmed and sat down. But they didn't do that. Instead, Easterbrook and the panel go out of their way to reject a well-established 25-year-old precedent that has been followed consistently by the other circuits and by all the lower courts. And in doing that, then the Seventh Circuit creates a circuit split that didn't exist before. And it's not really clear why Easterbrook felt compelled to do this, because as I said, the Gartenberg precedent has no real teeth to it anyway, because the plaintiff always loses in any event. Now, what is the Roberts Court going to do with that? Will the Roberts Court stick with established law, or will it endorse the Seventh Circuit's new approach? Hard to know, but remember, Roberts himself claimed during the confirmation hearings that he was a fan of stare decisis and precedent. Here we get to see what he really thinks about that in a case that presents the issue quite starkly. Not the only one this term, but certainly one in which the issue is very salient. Final point, a quick point here, is that the case, the way the Roberts Court decides the case is going to give us some insights into the court's philosophy toward the regulation of business more generally. This is one of several cases before the court this term that deals with important business regulation issues. The free enterprise case that Professor Murchison talked about is one of them, because what's behind the big fight there, people don't, they don't lose sleep at night over the technicalities of the separation of powers doctrine. This is the question here, is whether the government ought to be regulating the accounting profession as a way of regulating corporations who otherwise might be inclined to engage in fraud. That's what the real fight is about in that case. In addition, there's a case, the Citizens United case, which is a corporate free speech case. Should corporations have the right to engage in free speech the way the rest of us do, or should there be a separate body of doctrine that applies to corporations? Very important issue. That's going to be decided. Again, they have a chance to overrule another well-settled precedent in that case as well. And there's some other ones. So we're going to find out, I think, this term, this case will be one of the signposts there, how the Roberts Court feels about the regulation of corporations in America. Should these issues be left by and large to private ordering, to the markets, or is there a significant role for government to play here in regulating business activity?
Well, I want to thank all our speakers again, and I want to thank all of you for coming. We have a reception out in the lobby where I hope you'll join us for some conversation with some of our fine academic panelists here. Please join me once again in thanking our outstanding speakers.